Opinion of the Court. Supreme Court of the United States. Haaland, Secretary of the Interior, et al. V. Brackeen et al. On certiorari to the United States Court of Appeals for the Fifth Circuit. June 15, 2023. Justice Barret delivered the opinion of the court. This case is about children who are among the most vulnerable, those in the child welfare system. In the usual course, state courts apply state law when placing children in foster or adoptive homes. But when the child is an Indian, a federal statute, the Indian Child Welfare Act, governs. Among other things, this law requires a state court to place an Indian child with an Indian caretaker, if one is available. That is so even if the child is already living with a non-Indian family, and the state court thinks it in the child's best interest to stay there. Before us, a birth mother, foster and adoptive parents, and the state of Texas challenge the act on multiple constitutional grounds. They argue that it exceeds federal authority, infringes state sovereignty, and discriminates on the basis of race. The United States, joined by several Indian tribes, defends the law. The issues are complicated, so for the details, read on. But the bottom line is that we reject all of petitioners' challenges to the statute, some on the merits and others for lack of standing. Opinion, Section 1A. In 1978, Congress enacted the Indian Child Welfare Act ICWA out of concern that an alarmingly high percentage of Indian families are broken up by the removal, often unwarranted, of their children from them by non-tribal public and private agencies. 92 Statutes at Large 3069, 25 United States Code, Section 19014. Congress found that many of these children were being placed in non-Indian foster and adoptive homes and institutions, and that the states had contributed to the problem by failing to recognize the essential tribal relations of Indian people and the cultural and social standards prevailing in Indian communities and families. Sections 19014-5. This harmed not only Indian parents and children, but also Indian tribes. As Congress put it, there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. Section 19013. Testifying before Congress, the tribal chief of the Mississippi Band of Choctaw Indians was blunter. Culturally, the chances of Indian survival are significantly reduced if our children, the only real means for the transmission of the tribal heritage, are to be raised in non-Indian homes and denied exposure to the ways of their people. Hearings on S-1214 before the Subcommittee on Indian Affairs and Public Lands of the House Committee on Interior and Insular Affairs, 95th Congress, 2nd Session, 193-1978. The Act thus aims to keep Indian children connected to Indian families. Indian child is defined broadly to include not only a child who is a member of an Indian tribe, but also one who is eligible for membership in an Indian tribe and is the biological child of a member of an Indian tribe. Section 19034. If the Indian child lives on a reservation, ICWA grants the tribal court exclusive jurisdiction over all child custody proceedings, including adoptions and foster care proceedings. Section 1911A. For other Indian children, state and tribal courts exercise concurrent jurisdiction, although the state court is sometimes required to transfer the case to tribal court. Section 1911B. When a state court adjudicates the proceeding, ICWA governs from start to finish. That is true regardless of whether the proceeding is involuntary one, to which the parents do not consent, or voluntary one, to which they do. Involuntary proceedings are subject to especially stringent safeguards. Any party who initiates an involuntary proceeding in state court to place an Indian child in foster care or terminate parental rights must notify the parent or Indian custodian and the Indian child's tribe. Section 1912A. The parent or custodian and tribe have the right to intervene in the proceedings, the right to request extra time to prepare for the proceedings, the right to examine all reports or other documents filed with the court, and for indigent parents or custodians, the right to court-appointed counsel. Sections 1912A-B-C. The party attempting to terminate parental rights or remove an Indian child from an unsafe environment must first satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. Section 1912d. Even then, the court cannot order a foster care placement unless it finds by clear and convincing evidence, including testimony of qualified expert witnesses, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. Section 1912e. To terminate parental rights, the court must make the same finding beyond a reasonable doubt. Section 1912f. The Act applies to voluntary proceedings too. Relinquishing a child temporarily to foster care or permanently to adoption is a grave act, and a state court must ensure that a consenting parent or custodian knows and understands the terms and consequences. Section 1913a. Notably, a biological parent who voluntarily gives up an Indian child cannot necessarily choose the child's foster or adoptive parents. The child's tribe has a right to intervene at any point in a proceeding to place a child in foster care or terminate parental rights, as well as a right to collaterally attack the state court's decree. Sections 1911c, 1914. As a result, the tribe can sometimes enforce ICWA's placement preferences against the wishes of one or both biological parents, even after the child is living with a new family. See Mississippi Band of Choctaw Indians v. Hollifield 1989. ICWA's placement preferences, which apply to all custody proceedings involving Indian children, are hierarchical. State courts may only place the child with someone in a lower-ranked group when there is no available placement in a higher-ranked group. For adoption, a preference shall be given to placements with one a member of the child's extended family, two other members of the Indian child's tribe, or three other Indian families. Section 1915a. For foster care, a preference is given to one the Indian child's extended family, two a foster home licensed, approved, or specified by the Indian child's tribe, three an Indian foster home licensed or approved by an authorized non-Indian licensing authority, and then four another institution approved by an Indian tribe or operated by an Indian organization which has a program suitable to meet the Indian child's needs. Section 1915b. For purposes of the placement preferences, an Indian is any person who is a member of an Indian tribe, and an Indian organization is any group owned or controlled by Indians. Sections 19,033, 7. Together, these definitions mean that Indians from any tribe, not just the tribe to which the child has a tie, outrank unrelated non-Indians for both adoption and foster care. And for foster care, institutions run or approved by any tribe outrank placements with unrelated non-Indian families. Courts must adhere to the placement preferences absent good cause to depart from them. Sections 1915a-b. The child's tribe may pass a resolution altering the prioritization order. Section 1915c. If it does, the agency or court effecting the placement shall follow such order so long as the placement is the least restrictive setting appropriate to the particular needs of the child. So long as the least restrictive setting condition is met, the preferences of the Indian child or her parent cannot trump those set by statute or tribal resolution. But where appropriate, the preference of the Indian child or parent shall be considered in making a placement. The state must record each placement, including a description of the efforts made to comply with ICWA's order of preferences. Section 1915e. Both the Secretary of the Interior and the child's tribe have the right to request the record at any time. State courts must also transmit all final adoption decrees and specified information about adoption proceedings to the Secretary. Section 1951a. Opinion Section 1b. This case arises from three separate child custody proceedings governed by ICWA. Opinion Section 1b1. ALM was placed in foster care with Chad and Jennifer Brackeen when he was 10 months old. Because his biological mother is a member of the Navajo Nation and his biological father is a member of the Cherokee Nation, he falls within ICWA's definition of an Indian child. Both the Brackeens and ALM's biological parents live in Texas. After ALM had lived with the Brackeens for more than a year, they sought to adopt him. ALM's biological mother, father, and grandmother all supported the adoption. The Navajo and Cherokee nations did not. Pursuant to an agreement between the tribes, the Navajo Nation designated ALM as a member and informed the state court that it had located a potential alternative placement with non-relative tribal members living in New Mexico. ICWA's placement preferences ranked the proposed Navajo family ahead of non-Indian families like the Brackeens. The Brackeens tried to convince the state court that there was good cause to deviate from ICWA's preferences. They presented favorable testimony from ALM's court-appointed guardian and from a psychological expert who described the strong emotional bond between ALM and his foster parents. ALM's biological parents and grandmother also testified, urging the court to allow ALM to remain with the Brackeens, the only parents ALM knows. The court denied the adoption petition, and the Texas Department of Family and Protective Services announced its intention to move ALM from the Brackeens home to New Mexico. In response, the Brackeens obtained an emergency stay of the transfer and filed this lawsuit. The Navajo family then withdrew from consideration, and the Brackeens finalized their adoption of ALM. The Brackeens now seek to adopt ALM's biological sister, YRJ, again over the opposition of the Navajo Nation. And while the Brackeens hope to foster and adopt other Indian children in the future, their fraught experience with ALM's adoption makes them hesitant to do so. Opinion Section 1B2. Altagracia Hernandez chose Nick and Heather Libretti as adoptive parents for her newborn daughter. Baby O. The Librettis took Baby O home from the hospital when she was 3 days old, and Hernandez, who lived nearby, visited Baby O frequently. Baby O's biological father visited only once but supported the adoption. Hernandez is not an Indian, but Baby O's biological father is descended from members of the Isleta del Sur Pueblo tribe, and the tribe enrolled Baby O as a member. As a result, the adoption proceeding was governed by ICWA. The tribe exercised its right to intervene and argued, over Hernandez's objection, that Baby O should be moved from the Libretti's home in Nevada to the tribe's reservation in El Paso, Texas. It presented a number of potential placements on the reservation for Baby O, and state officials began to investigate them. After Hernandez and the Librettis joined this lawsuit, however, the tribe withdrew its challenge to the adoption, and the Librettis finalized their adoption of Baby O. The Librettis stayed in the litigation because they planned to foster and possibly adopt Indian children in the future. Opinion Section 1B3. Jason and Danielle Clifford, who live in Minnesota, fostered child P, whose maternal grandmother belongs to the White Earth Band of Ojibwe tribe. When child P entered state custody around the age of 3, her mother informed the court that ICWA did not apply because child P was not eligible for tribal membership. The tribe wrote a letter to the court confirming the same. After 2 years in the foster care system, child P was placed with the Cliffords, who eventually sought to adopt her. The tribe intervened in the proceedings and, with no explanation for its change in position, informed the court that child P was in fact eligible for tribal membership. Later, the tribe announced that it had enrolled child P as a member. To comply with ICWA, Minnesota placed child P with her maternal grandmother, who had lost her foster license due to a criminal conviction. The Cliffords continued to pursue the adoption, but citing ICWA, the court denied their motion. Like the other families, the Cliffords intend to foster or adopt Indian children in the future. Opinion Section 1C. The Brackeens, the Librettis, Hernandez, and the Cliffords, whom we will refer to collectively as the individual petitioners, filed this suit in federal court against the United States, the Department of the Interior and its Secretary, the Bureau of Indian Affairs BIA and its Director, and the Department of Health and Human Services and its Secretary, whom we will refer to collectively as the federal parties. The individual petitioners were joined by the states of Texas, Indiana, and Louisiana, although only Texas continues to challenge ICWA before this court. Several Indian tribes intervened to defend the law alongside the federal parties. Petitioners challenged ICWA as unconstitutional on multiple grounds. They asserted that Congress lacks authority to enact ICWA and that several of ICWA's requirements violate the anti-commandeering principle of the 10th Amendment. They argued that ICWA employs racial classifications that unlawfully hinder non-Indian families from fostering or adopting Indian children. And they challenged Section 1915C, the provision that allows tribes to alter the prioritization order on the ground that it violates the non-delegation doctrine. The district court granted petitioners' motion for summary judgment on their constitutional claims, and a divided panel of the Fifth Circuit reversed. After rehearing the case in banc, the Fifth Circuit affirmed in part and reversed in part. The en-banc court concluded that ICWA does not exceed Congress's legislative power, that Section 1915C does not violate the non-delegation doctrine, and that some of ICWA's placement preferences satisfy the guarantee of equal protection. The court was evenly divided as to whether ICWA's other preferences, those prioritizing other Indian families and Indian foster homes over non-Indian families, unconstitutionally discriminate on the basis of race. The Fifth Circuit therefore affirmed the district court's ruling that these preferences are unconstitutional. Petitioners' 10th Amendment arguments effectively succeeded across the board. The Fifth Circuit held that Section 1912D's active efforts requirement, Section 1912E's and Section 1912F's expert witness requirements, and Section 1915E's record-keeping requirement unconstitutionally commandeer the states. It divided evenly with respect to the other provisions that petitioners challenge here. Section 1912A's notice requirement, Section 1915A and Section 1915B's placement preferences, and Section 1951A's record-keeping requirement. So the Fifth Circuit affirmed the district courts holding that these requirements, too, violate the 10th Amendment. We granted certiorari. Opinion Section 2A. We begin with petitioners' claim that ICWA exceeds Congress's power under Article 1. In a long line of cases, we have characterized Congress's power to legislate with respect to the Indian tribes as plenary and exclusive. United States v. Lara 2004. South Dakota v. Yankton Sioux Tribe, 1998 Congress possesses plenary power over Indian affairs. Washington v. Confederated Bands and Tribes of Yakama Nation 1979, Congress exercises plenary and exclusive power over Indian affairs. Winton v. Amos 1921, it is thoroughly established that Congress has plenary authority over the Indians and all their tribal relations. Lone Wolf v. Hitchcock 1903 Congress possesses a paramount power over the property of the Indians. Stevens v. Cherokee Nation 1899 Congress possesses plenary power of legislation in regard to the Indian tribes. Our cases leave little doubt that Congress's power in this field is muscular, superseding both tribal and state authority. Santa Clara Pueblo v. Martinez 1978 Congress has plenary authority to limit, modify, or eliminate the powers of local self-government, which the tribes otherwise possess. Dick v. United States 1908 Congress has power to regulate commerce with the Indian tribes, and such power is superior and paramount to the authority of any state within whose limits are Indian tribes. To be clear, however, plenary does not mean free-floating. A power unmoored from the Constitution would lack both justification and limits. So, like the rest of its legislative powers, Congress's authority to regulate Indians must derive from the Constitution, not the atmosphere. Our precedent traces that power to multiple sources. The Indian Commerce Clause authorizes Congress to regulate commerce with the Indian tribes. Article 1, Section 8, Clause 3. We have interpreted the Indian Commerce Clause to reach not only trade, but certain Indian affairs too. Cotton Petroleum Corp. v. New Mexico 1989. Notably, we have declined to treat the Indian Commerce Clause as interchangeable with the Interstate Commerce Clause. While under the Interstate Commerce Clause, states retain some authority over trade, we have explained that virtually all authority over Indian commerce and Indian tribes lies with the federal government. Seminole Tribe of Florida v. Florida, 1996. The treaty clause which provides that the President shall have power, by and with the advice and consent of the Senate, to make treaties provides a second source of power over Indian affairs. Article 2, Section 2, Clause 2. Until the late 19th century, relations between the federal government and the Indian tribes were governed largely by treaties. United States v. Lara 2004. Of course, the treaty power does not literally authorize Congress to act legislatively, since it is housed in Article 2 rather than Article 1. Nevertheless, We have asserted that treaties made pursuant to that power can authorize Congress to deal with matters with which otherwise Congress could not deal. And even though the United States formally ended the practice of entering into new treaties with the Indian tribes in 1871, this decision did not limit Congress's power to legislate on problems of Indians pursuant to pre-existing treaties. Anton v. Washington, 1975. We have also noted that principles inherent in the Constitution's structure empower Congress to act in the field of Indian affairs. See Morton v. Mankery, 1974. The plenary power of Congress to deal with the special problems of Indians is drawn both explicitly and implicitly from the Constitution itself. At the founding, Indian affairs were more an aspect of military and foreign policy than a subject of domestic or municipal law. United States v. Lara, 2004. With this in mind, we have posited that Congress's legislative authority might rest in part on the Constitution's adoption of pre-constitutional powers necessarily inherent in any federal government, namely, powers that this court has described as necessary concomitants of nationality. Lara, 2004, quoting United States v. Curtis, Wright Export Corp. 1936. Finally, the trust relationship between the United States and the Indian people informs the exercise of legislative power. United States v. Mitchell, 1983. As we have explained, the federal government has charged itself with moral obligations of the highest responsibility and trust toward Indian tribes. United States v. Hickorea Apache Nation, 2011. Seminole Nation v. United States, 1942. This court has recognized the distinctive obligation of trust incumbent upon the government in its dealings with these dependent and sometimes exploited people. The contours of this special relationship are undefined. Mankery, 1974. In sum, Congress's power to legislate with respect to Indians is well established and broad. Consistent with that breadth, we have not doubted Congress's ability to legislate across a wide range of areas, including criminal law, domestic violence, employment, property, tax, and trade. See example given, Lara, 2004, law allowing tribes to prosecute non-member Indians who committed crimes on tribal land. United States v. Bryant, 2016, law criminalizing domestic violence in Indian country. Mankery, 1974, policy granting Indians employment preferences. United States v. Antelope, 1977, law establishing a criminal code for Indian country. Yankton Sioux Tribe, law altering the boundaries of a reservation. Sunderland v. United States, 1924, agency action removing the restrictions on alienation of a homestead allotted to an Indian. Warren Trading Post Company v. Arizona Tax Commission, 1965, law granting tribe immunity from state taxation. United States v. Algoma Lumber Company, 1939, law regulating the sale of timber by an Indian tribe. Indeed, we have only rarely concluded that a challenge statute exceeded Congress's power to regulate Indian affairs. See example given, Seminole Tribe, 1996. Admittedly, our precedent is unwieldy because it rarely ties a challenge statute to a specific source of constitutional authority. That makes it difficult to categorize cases and even harder to discern the limits on Congress's power. Still, we have never wavered in our insistence that Congress's Indian affairs power is not absolute. Delaware Tribal Business Commission v. Weeks, 1977, United States v. Alcia Band of Tillamook's, 1946, the power of Congress over Indian affairs may be of a plenary nature, but it is not absolute. United States v. Creek Nation, 1935, plenary power is subject to limitations inherent in such a guardianship and to pertinent constitutional restrictions. It could not be otherwise. Article 1 gives Congress a series of enumerated powers, not a series of blank checks. Thus, we reiterate that Congress's authority to legislate with respect to Indians is not unbounded. It is plenary within its sphere, but even a sizable sphere has borders. Opinion Section 2b. Petitioners contend that ICWA exceeds Congress's power. Their principal theory, and the one accepted by both Justice Alito and the dissenters in the Fifth Circuit, is that ICWA treads on the state's authority over family law. Domestic relations have traditionally been governed by state law. Thus, federal power over Indians stops where state power over the family begins. or so the argument goes. It is true that Congress lacks a general power over domestic relations, in Re Burris 1890, and, as a result, responsibility for regulating marriage and child custody remains primarily with the states, Sosna v. Iowa 1975. See also Moore v. Sims 1979. But the Constitution does not erect a firewall around family law. On the contrary, when Congress validly legislates pursuant to its Article I powers, we have not hesitated to find conflicting state family law preempted, notwithstanding the limited application of federal law in the field of domestic relations generally. Ridgway v. Ridgway 1981 federal law providing life insurance preempted state family property law. See also Hillman v. Moretta, 2013, state laws, governing the economic aspects of domestic relations, must give way to clearly conflicting federal enactments alteration in original. In fact, we have specifically recognized Congress's power to displace the jurisdiction of state courts in adoption proceedings involving Indian children. Fisher v. District Court of 16th Judicial District of Montana 1976. Petitioners are trying to turn a general observation that Congress's Article I powers rarely touch state family law into a constitutional carve-out that family law is wholly exempt from federal regulation. That argument is a non-starter. As James Madison said to members of the First Congress, when the Constitution conferred a power on Congress, they might exercise it, although it should interfere with the laws or even the Constitution of the states. 2 Annals of Congress, 1897-1791. Family law is no exception. Opinion Section 2C. Petitioners come at the problem from the opposite direction too. Even if there is no family law carve-out to the Indian affairs power, they contend that Congress's authority does not stretch far enough to justify ICWA. Ticking through the various sources of power, petitioners assert that the Constitution does not authorize Congress to regulate custody proceedings for Indian children. Their arguments fail to grapple with our precedent, and because they bear the burden of establishing ICWA's unconstitutionality, we cannot sustain their challenge to the law. See Lujan v. G. and G. Fire Sprinklers, Incorporated 2001. Take the Indian Commerce Clause, which is petitioners' primary focus. According to petitioners, the clause authorizes Congress to legislate only with respect to Indian tribes as government entities, not Indians as individuals. But we held more than a century ago that commerce with the Indian tribes means commerce with the individuals composing those tribes. United States v. Holiday 1866, law prohibiting the sale of alcohol to Indians in Indian country. United States v. Nice 1916. So that argument is a dead end. Petitioners also assert that ICWA takes the commerce out of the Indian Commerce Clause. Their consistent refrain is that children are not commodities that can be traded. Brief for individual petitioners, brief for petitioner Texas children are not commodities. Children are not articles of commerce. Rhetorically, it is a powerful point. Of course, children are not commercial products. Legally, though, it is beside the point. As we already explained, our precedent states that Congress's power under the Indian Commerce Clause encompasses not only trade, but also Indian affairs. Cotton Petroleum Corporation v. New Mexico 1989. Even the judges who otherwise agreed with petitioners below rejected this narrow view of the Indian Commerce Clause as inconsistent with both our cases and long-standing patterns of federal legislation. Rather than dealing with this precedent, however, petitioners virtually ignore it. Next, petitioners argue that ICWA cannot be authorized by principles inherent in the Constitution's structure because those principles extend, at most, to matters of war and peace. Brief for petitioner Texas. But that is not what our cases say. We have referred generally to the powers necessarily inherent in any federal government, and we have offered examples like creating departments of Indian affairs, appointing Indian commissioners, and securing and preserving the friendship of the Indian nations, none of which are military actions. Lara 2004. Once again, petitioners make no argument that takes our cases on their own terms. Finally, petitioners observe that ICWA does not implement a federal treaty. Brief for petitioner Texas, brief for individual petitioners. This does not get them very far either, since Congress did not purport to enact ICWA pursuant to the treaty clause power, and the Fifth Circuit did not uphold ICWA on that rationale. Presumably recognizing these obstacles, petitioners turned to criticizing our precedent as inconsistent with the Constitution's original meaning. Yet here, too, they offer no account of how their argument fits within the landscape of our case law. For instance, they neither ask us to overrule the precedent they criticize nor try to reconcile their approach with it. They are also silent about the potential consequences of their position. Would it undermine established cases and statutes? If so, which ones? Petitioners do not say. We recognize that our case law puts petitioners in a difficult spot. We have often sustained Indian legislation without specifying the source of Congress's power, and we have insisted that Congress's power has limits without saying what they are. Yet petitioners' strategy for dealing with the confusion is not to offer a theory for rationalizing this body of law. That would at least give us something to work with. Instead, they frame their arguments as if the slate were clean. More than 2 centuries in, it is anything but. If there are arguments that ICWA exceeds Congress's authority as our precedent stands today, petitioners do not make them. We therefore decline to disturb the Fifth Circuit's conclusion that ICWA is consistent with Article 1. Opinion Section 3. We now turn to petitioners' host of anti-commandeering arguments, which we will break into 3 categories. First, petitioners challenge certain requirements that apply in involuntary proceedings to place a child in foster care or terminate parental rights. The requirements that an initiating party demonstrate active efforts to keep the Indian family together, serve notice of the proceeding on the parent or Indian custodian and tribe, and demonstrate, by a heightened burden of proof and expert testimony, that the child is likely to suffer serious emotional or physical damage if the parent or Indian custodian retains custody. Second, petitioners challenge ICWA's placement preferences. They claim that Congress can neither force state agencies to find preferred placements for Indian children nor require state courts to apply federal standards when making custody determinations. Third, they insist that Congress cannot force state courts to maintain or transmit to the federal government records of custody proceedings involving Indian children. 5. Opinion Section 3A. As a reminder, involuntary proceedings are those to which a parent does not consent. Section 1912, 25 Code of Federal Regulations Section 23.2. Heightened protections for parents and tribes apply in this context, and while petitioners challenge most of them, the active efforts provision is their primary target. That provision requires any party seeking to effect an involuntary foster care placement or termination of parental rights to satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. Section 1912D. According to petitioners, this subsection directs state and local agencies to provide extensive services to the parents of Indian children. It is well established that the 10th Amendment bars Congress from commanding the state's officers or those of their political subdivisions to administer or enforce a federal regulatory program. Prince 1997. The active efforts provision petitioners say does just that. Petitioners' argument has a fundamental flaw. To succeed, they must show that Section 1912D harnesses a state's legislative or executive authority. But the provision applies to any party who initiates an involuntary proceeding, thus sweeping in private individuals and agencies as well as government entities. A demand that either public or private actors can satisfy is unlikely to require the use of sovereign power. Murphy v. National Collegiate Athletic Association, 2018. Notwithstanding the term any party, petitioners insist that Section 1912D is best read as a command to the states. See Murphy 2018. Whether a federal law directly regulates the states depends on how it is best read. They contend that, as a practical matter, states, not private parties, initiate the vast majority of involuntary proceedings. Despite the breadth of the language, the argument goes, states are obviously the parties to whom the statute refers. The record contains no evidence supporting the assertion that states institute the vast majority of involuntary proceedings. Examples of private suits are not hard to find, so we are skeptical that their number is negligible. See example given, Adoptive Couple v. Baby Girl 2013. In re Guardianship of Eliza W. 2020 Grandmother. In re Guardianship of J.C.D. 2004 Grandparents. In re Adoption of T.A.W. 2016 in banc Mother and Stepfather. J.W. v. R.J. Alaska 1998. Indeed, Texas's own family code permits certain private parties to initiate suits for the termination of parental rights. Texas Family Code annotated section 102.003a, see reply brief for Texas 27. And while petitioners treat active efforts as synonymous with government programs, state courts have applied the active efforts requirement in private suits too. See example given, in re Adoption of T.A.W. 2016. SSV Stephanie H. 2017, in re NB 2007. That is consistent with ICWA's findings, which describe the role that both public and private actors played in the unjust separation of Indian children from their families and tribes. Section 1901. Given all this, it is implausible that Section 1912d is directed primarily, much less exclusively, at the states. Legislation that applies even-handedly to state and private actors does not typically implicate the 10th Amendment. Murphy 2018. In South Carolina v. Baker, for example, we held that a generally applicable law regulating unregistered bonds did not commandeer the states. Rather, it required states wishing to engage in certain activity to take administrative and sometimes legislative action to comply with federal standards regulating that activity. South Carolina v. Baker 1988. We reached a similar conclusion in Reno v. Condon, which dealt with a statute prohibiting state motor vehicle departments DMVs from selling a driver's personal information without the driver's consent. Reno v. Condon 2000. The law regulated not only the state DMVs, but also private parties who had already purchased this information and sought to resell it. Applying Baker, we concluded that the act did not require the states in their sovereign capacity to regulate their own citizens, enact any laws or regulations, or assist in the enforcement of federal statutes regulating private individuals. Instead, it permissibly regulated the states as the owners of databases. Petitioners argue that Baker and Condon are distinguishable because they addressed laws regulating a state's commercial activity, while ICWA regulates a state's core, sovereign function of protecting the health and safety of children within its borders. Brief for petitioner Texas. A state can stop selling bonds or a driver's personal information, petitioners say, but it cannot withdraw from the area of child welfare. Protecting children is the business of government, even if it is work in which private parties share. Nor, of course, could Texas avoid ICWA by excluding only Indian children from social services. Because states cannot exit the field, they are hostage to ICWA, which requires them to implement Congress's regulatory program for the care of Indian children and families. Reply brief for Texas. This argument is presumably directed at situations in which only the state can rescue a child from neglectful parents. But Section 1912 applies to more than child neglect. For instance, it applies when a biological mother arranges for a private adoption without the biological father's consent. See example given, Adoptive Couple 2013. And even when a child is trapped in an abusive home, the state is not necessarily the only option for rescue. For instance, a grandmother can seek guardianship of a grandchild whose parents are failing to care for her. See example given, in re Guardianship of Eliza W. Petitioners do not distinguish between these varied situations, much less isolate a domain in which only the state can act. Some amici assert that, at the very least, removing children from imminent danger in the home falls exclusively to the government. Brief for Academy of Adoption and Assisted Reproduction Attorneys, et al. As amici curiae 14 amici are aware of no state in which a private actor may lawfully remove a child from his existing home. Maybe so, but that does not help petitioners' commandeering argument, because the active efforts requirement does not apply to emergency removals. Section 1922. If ICWA commandeers state performance of a core sovereign function, petitioners do not give us the details. When a federal statute applies on its face to both private and state actors, a commandeering argument is a heavy lift, and petitioners have not pulled it off. both state and private actors initiate involuntary proceedings. And, if there is a core of involuntary proceedings committed exclusively to the sovereign, Texas neither identifies its contours nor explains what Section 1912d requires of a state in that context. Petitioners have therefore failed to show that the active efforts requirement commands the states to deploy their executive or legislative power to implement federal Indian policy. As for petitioners' challenges to other provisions of Section 1912, the notice requirement, expert witness requirement, and evidentiary standards, we doubt that requirements placed on a state as litigant implicate the 10th Amendment. But in any event, these provisions, like Section 1912d, apply to both private and state actors, so they too pose no anti-commandeering problem. Opinion Section 3b. Petitioners also raise a 10th Amendment challenge to Section 1915, which dictates placement preferences for Indian children. According to petitioners, this provision orders state agencies to perform a diligent search for placements that satisfy ICWA's hierarchy. Brief for petitioner Texas. See also brief for individual petitioners. Petitioners assert that the Department of the Interior understands Section 1915 this way: 25 Code of Federal Regulations Section 23.132c5, and the tribes who intervene in proceedings governed by ICWA share that understanding. For example, the Libretti's adoption of Baby O was delayed because the Isla del Sur Pueblo tribe demanded that county officials exhaustively search for a placement with the tribe first. Reply brief for Texas. Just as Congress cannot compel state officials to search databases to determine the lawfulness of gun sales, Prince 1997, petitioners argue, Congress cannot compel state officials to search for a federally preferred placement. As an initial matter, this argument encounters the same problem that plagues petitioners with respect to Section 1912. Petitioners have not shown that the diligent search requirement, which applies to both private and public parties, demands the use of state sovereign authority. But this argument fails for another reason too. Section 1915 does not require anyone, much less the states, to search for alternative placements. As the United States emphasizes, petitioners' interpretation cannot be squared with this court's decision in Adoptive Couple, which held that there simply is no preference to apply if no alternative party that is eligible to be preferred has come forward. Brief for federal parties. Adoptive Couple 2013 Section 1915A's preferences are inapplicable in cases where no alternative party has formally sought to adopt the child. Instead, the burden is on the tribe or other objecting party to produce a higher-ranked placement. So, as it stands, petitioners assert an anti-commandeering challenge to a provision that does not command state agencies to do anything. State courts are a different matter. ICWA indisputably requires them to apply the placement preferences in making custody determinations. Sections 1915A, B petitioners argue that this too violates the anti-commandeering doctrine. To be sure, they recognize that Congress can require state courts, unlike state executives and legislatures, to enforce federal law. See New York v. United States 1992. Federal statutes enforceable in state courts do, in a sense, direct state judges to enforce them, but this sort of federal direction of state judges is mandated by the text of the Supremacy Clause. But they draw a distinction between requiring state courts to entertain federal causes of action and requiring them to apply federal law to state causes of action. They claim that if state law provides the cause of action, as Texas law does here, then the state gets to call the shots, unhindered by any federal instruction to the contrary. Brief for individual petitioners. This argument runs headlong into the Constitution. The Supremacy Clause provides that the laws of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Article 6, Clause 2. Thus, when Congress enacts a valid statute pursuant to its Article 1 powers, state law is naturally preempted to the extent of any conflict with a federal statute. Crosby v. National Foreign Trade Council 2000. End of story. That a federal law modifies a state law cause of action does not limit its preemptive effect. See example given, Hillman 2013, holding federal law establishing an order of precedence for beneficiaries of life insurance preempted state law. Egelhoff v. Egelhoff 2001, Employee Retirement Income Security Act preempted state law regarding the economic consequences of divorce. Wisner v. Wisner 1950, Federal Military Benefits Law preempted state community property rules. Opinion Section 3C. Finally, we turn to ICWA's record-keeping provisions. Section 1951A requires courts to provide the Secretary of the Interior with a copy of the final order in the adoptive placement of any Indian child. The court must also provide other information, as may be necessary to show the child's name and tribal affiliation, the names and addresses of the biological parents and adoptive parents, and the identity of any agency with information about the adoptive placement. Section 1915E requires the state to maintain a record evidencing the efforts to comply with the order of preference specified by ICWA. The record shall be made available at any time upon the request of the Secretary or the Indian child's tribe. Petitioners argue that Congress cannot conscript the states into federal service by assigning them record-keeping tasks. The anti-commandeering doctrine applies distinctively to a state court's adjudicative responsibilities. Prince 1997. As we just explained, this distinction is evident in the Supremacy Clause, which refers specifically to state judges. Article 6, Clause 2. From the beginning, the text manifested in practice. As originally understood, the Constitution allowed Congress to require state judges to enforce federal prescriptions, insofar as those prescriptions related to matters appropriate for the judicial power. Prince 1997. In Prince, we indicated that this principle may extend to tasks that are ancillary to a quintessentially adjudicative task, such as recording, registering, and certifying documents. Petitioners reject Prince's observation, insisting that there is a distinction between rules of decision, which state courts must follow, and record-keeping requirements, which they can ignore. But Prince described numerous historical examples of Congress imposing record-keeping and reporting requirements on state courts. The early Congresses passed laws directing state courts to perform certain tasks fairly described as ancillary to the court's adjudicative duties. For example, state courts were required to process and record applications for United States citizenship. The clerk or other court official was required to certify and transmit the application to the Secretary of State, along with information about the name, age, nation, residence, and occupation, for the time being, of the alien. Act of June 18, 1798, Section 2. The clerk also had to register aliens seeking naturalization and issue certificates confirming the court's receipt of the alien's request for registration. Act of April 14, 1802, Section 2. Federal law imposed other duties on state courts unrelated to immigration and naturalization. The Judiciary Act of 1789, which authorized any justice of the peace or other magistrate of any of the United States to arrest and imprison federal offenders, required the judge to set bail at the defendant's request. Congress also required state courts to administer oaths to prisoners, to issue certificates authorizing the apprehension of fugitives, and to collect proof of the claims of Canadian refugees who had aided the United States in the Revolutionary War. Act of May 5, 1792, Chapter 29, Section 2, any person imprisoned may have the oath or affirmation herein after expressed administered to him by any judge of the United States, or of the General or Supreme Court of Law of the state in which the debtor is imprisoned. Act of February 12, 1793, Chapter 7, Section 1, Governor or Chief Magistrate of the state or territory shall certify as authentic an indictment or affidavit charging a fugitive from justice. Act of April 7, 1798, Section 3, proof of the several circumstances necessary to entitle the applicants to the benefits of this act, may be taken before a judge of the Supreme or Superior Court, or the first justice or first judge of the Court of Common Pleas or Country Court of any state. There is more. Shortly after ratification, Congress passed a detailed statute that required state court judges to gather and certify reports. Act of July 20, 1790, Section 3. The act authorized commanders of ships to request examinations of their vessels from any justice of the peace of the city, town, or place. The judge would order 3 qualified people to prepare a report on the vessel's condition, which the judge would review and endorse. Then, the judge was required to issue an order regarding whether the said ship or vessel is fit to proceed on the intended voyage, and if not, whether such repairs can be made or deficiencies supplied where the ship or vessel then lays. These early congressional enactments provide contemporaneous and weighty evidence of the Constitution's meaning. Bosher v. Sinar, 1986. Collectively, they demonstrate that the Constitution does not prohibit the federal government from imposing adjudicative tasks on state courts. This makes sense against the backdrop of the Madisonian Compromise, since Article 3 established only the Supreme Court and made inferior federal courts optional. Congress could have relied almost entirely on state courts to apply federal law. Prince, 1997. Had Congress taken that course, it would have had to rely on state courts to perform adjudication-adjacent tasks too. We now confirm what we suggested in Prince. Congress may impose ancillary record-keeping requirements related to state court proceedings without violating the 10th Amendment. Such requirements do not offload the federal government's responsibilities onto the states, nor do they put state legislatures and executives under the direct control of Congress. Murphy, 2018. Rather, they are a logical consequence of our system of dual sovereignty, in which state courts are required to apply federal law. See Gregory v. Ashcroft, 1991. Here, ICWA's record-keeping requirements are comparable in kind and in degree to the historical examples. Like the naturalization laws, Section 1951A requires the state court to transmit to the Secretary a copy of a court order along with basic demographic information. Section 1915E likewise requires the state to record a limited amount of information, the efforts made to comply with the placement preferences, and provide the information to the Secretary and to the child's tribe. These duties are ancillary to the state court's obligation to conduct child custody proceedings in compliance with ICWA. Prince, 1997. Thus, ICWA's record-keeping requirements are consistent with the 10th Amendment. Opinion Section 4. Petitioners raise 2 additional claims: an equal protection challenge to ICWA's placement preferences and a non-delegation challenge to the provision allowing tribes to alter the placement preferences. We do not reach the merits of these claims because no party before the court has standing to raise them. Article 2I requires a plaintiff to show that she has suffered an injury, in fact, that is fairly traceable to the defendant's allegedly unlawful conduct and likely to be redressed by the requested relief. California v. Texas, 2021. Neither the individual petitioners nor Texas can pass that test. Opinion Section 4A. The individual petitioners argue that ICWA injures them by placing them on unequal footing with Indian parents who seek to adopt or foster an Indian child. Northeastern Florida Chapter, Associated General Contractors of America v. Jacksonville, 1993. Under ICWA's hierarchy of preferences, non-Indian parents are generally last in line for potential placements. According to petitioners, this erects a barrier that makes it more difficult for members of one group to obtain a benefit than it is for members of another group. See also Turner v. Fouch, 1970. The Equal Protection Clause secures the right of individuals to be considered for government positions and benefits without the burden of invidiously discriminatory disqualifications. The racial discrimination they allege counts as an Article 3 injury. But the individual petitioners have not shown that this injury is likely to be redressed by judicial relief. TransUnion, LLC v. Ramirez, 2021. They seek an injunction preventing the federal parties from enforcing ICWA and a declaratory judgment that the challenged provisions are unconstitutional. Yet enjoining the federal parties would not remedy the alleged injury, because state courts apply the placement preferences and state agencies carry out the court-ordered placements. Sections 19031, 1915 AB. See also brief for individual petitioners stating there is no federal official who administers ICWA or carries out its mandates. The state officials who implement ICWA are not parties to the suit, and there is no reason they should be obliged to honor an incidental legal determination the suit produced. Louisiana v. Defenders of Wildlife, 1992, plurality opinion. So an injunction would not give petitioners legally enforceable protection from the allegedly imminent harm. Petitioners' request for a declaratory judgment suffers from the same flaw. See Skelly Oil, Co. v. Phillips Petroleum, Co. 1950. This form of relief conclusively resolves the legal rights of the parties. Medtronic Inc. v. Morosky Family Ventures LLC 2014. But again, state officials are non-parties who would not be bound by the judgment. Taylor v. Sturgill 2008. Thus, the equal protection issue would not be settled between petitioners and the officials who matter, which would leave the declaratory judgment powerless to remedy the alleged harm. Costa, concurring in part and dissenting in part, what saves proper declaratory judgments from a redressability problem, but is lacking here is that they have preclusive effect on a traditional lawsuit that is imminent. After all, the point of a declaratory judgment is to establish a binding adjudication that enables the parties to enjoy the benefits of reliance and repose secured by res judicata. C. Wright, A. Miller, and E. Cooper, Federal Practice and Procedure Section 4446 2022. Without preclusive effect, a declaratory judgment is little more than an advisory opinion. See Public Service Commission of Utah v. Wyckoff, Co. 1952. The individual petitioners do not dispute or even address any of this. Instead, they insist that state courts are likely to defer to a federal court's interpretation of federal law, thus giving rise to a substantial likelihood that a favorable judgment will redress their injury. Brief in opposition for individual respondents, reply brief for individual petitioners. They point out that, in the Brackeen's ongoing efforts to adopt YRJ, the trial court stated that it would follow the federal court's ruling on the Brackeen's constitutional claims. Thus, they reason, winning this case would solve their problems. But redressability requires that the court be able to afford relief through the exercise of its power, not through the persuasive or even awe-inspiring effect of the opinion explaining the exercise of its power. Franklin v. Massachusetts 1992 Scalia, concurring in part and concurring in judgment. See also United States v. Juvenile Mail 2011, per curiam, a judgment's possible, indirect benefit in a future lawsuit does not preserve standing. Otherwise, redressability would be satisfied whenever a decision might persuade actors, who are not before the court contrary, to Article 3's strict prohibition on issuing advisory opinions. Carney v. Adams 2020. It is a federal court's judgment, not its opinion, that remedies an injury. Thus, it is the judgment, not the opinion, that demonstrates redressability. The individual petitioners can hope for nothing more than an opinion, so they cannot satisfy Article 3. Opinion Section 4. Texas also lacks standing to challenge the placement preferences. It has no equal protection rights of its own, South Carolina v. Katzenbach, 1966, and it cannot assert equal protection claims on behalf of its citizens because a state does not have standing as parens patriae to bring an action against the federal government, Alfred L. Snap, and Son Inc. v. Puerto Rico ex rel Barret, 1982. Yet Texas advances a few creative arguments for why it has standing despite these settled rules. It leads with what one might call an unclean hands injury. ICWA injures Texas by requiring it to break its promise to its citizens that it will be colorblind in child custody proceedings. Reply brief for Texas ICWA forces Texas to violate its own constitutional obligations. This is not the kind of concrete and particularized invasion of a legally protected interest necessary to demonstrate an injury in fact. Louisiana v. Defenders of Wildlife, 1992. Were it otherwise, a state would always have standing to bring constitutional challenges when it is complicit in enforcing federal law. Texas tries to finesse this problem by characterizing ICWA as a fiscal trap, forcing it to discriminate against its citizens or lose federal funds. Brief for petitioner Texas. But ICWA is not a spending clause statute. Texas bases this argument on a vague reference to a different spending clause statute that it does not challenge. And Texas has not established that those funds, which the state has accepted for years, are conditioned on compliance with the placement preferences anyway. See 42 United States Code, Section 622, brief for federal parties. Texas also claims a direct pocketbook injury associated with the costs of keeping records, providing notice in involuntary proceedings, and producing expert testimony before moving a child to foster care or terminating parental rights. Reply brief for Texas. But these alleged costs are not fairly traceable to the placement preferences, which operate independently of the provisions Texas identifies. California v. Texas, 2021. The provisions do not rise or fall together. Proving that the placement preferences are unconstitutional would not show that enforcement of any of these other provisions violates the Constitution. In other words, Texas would continue to incur the complained of costs even if it were relieved of the duty to apply the placement preferences. The former, then, cannot justify a challenge to the latter. Because Texas is not injured by the placement preferences, neither would it be injured by a tribal resolution that altered those preferences pursuant to Section 1915C. Texas, therefore, does not have standing to bring either its equal protection or its non-delegation claims. For these reasons, we affirm the judgment of the Court of Appeals regarding Congress's constitutional authority to enact ICWA. On the anti-commandeering claims, we reverse. On the equal protection and non-delegation claims, we vacate the judgment of the Court of Appeals and remand with instructions to dismiss for lack of jurisdiction. It is so ordered.